So thank you guys so much for attending our monthly Trust and Probate seminar with the Trust Brothers. They are also from Covina down the street. And we've known them for such a long time that we wanted to show our appreciation to our clients and our community just for giving us the referrals that we always get. But one token of appreciation is introducing them to the community too. They're already very popular. If you belong to Covina Buzz or West Covina Buzz, they're on there all the time. So the community loves them already, but we wanted to give them more love and show our community that we treasure you guys, and what better way but to educate you guys with trust. We know how important it is to have this document. As easy as it sounds, it's very difficult for the common person to actually acquire the information and to actually just be here. It's difficult. So we appreciate the commitment. They have a very concise presentation that will answer a lot of the questions. At the end of the presentation, they will be taking questions, personal questions, whatever you want to ask, they will answer. But again, we want to thank you for taking time on a Thursday evening to become educated. So I welcome you guys, and this is Ryan and Rory, and they are brothers, and I love them for being here and working together. It's very important for us to have them here. So again, welcome, and they'll be starting the seminar off, and at the end, they'll be opening up the platform for questions.
Thank you guys for coming
thank you guys
so much. Thank you, Karina, for having us. I am Ryan. This is my brother, Rory.
Thank you, everybody.
Just think of this as purely educational, right? Not going to pitch anything to you guys. I just want to give you guys the information. Really, trusts are about houses, right? And so we're going to talk about that throughout the night, really, explaining why trusts are about houses, okay? So I know this is the only slide that's kind of small, but a couple pieces from the beginning, right? Hello, come on in from the cold. We got some seating right here.
Yeah, let's maybe get the seating arranged.
Yep, cool. Just go over a couple of the basics, right? So this is called a living trust seminar, but it's really an estate planning seminar, right? Because really what you guys are looking for is an estate plan, which a living trust is one component, right? So every estate plan is going to have a living trust. It is going to have what's called a pour over will. It's going to have power of attorney. It's going to have medical directive. And depending on if you have minor children, it's going to have guardianships, right? So think of the estate plan as these multiple components, which the living trust is the primary piece, okay? Anytime you create an estate plan, a living trust, you've got to what's called fund that trust. And we're going to talk about that later, but you create this great living trust, and at the beginning, it owns nothing, right? It just says, it's just a piece of paper, right? Until you start transferring title of assets, primarily the house, into this trust. And we're going to talk later about how we do that. You always need a notary. For our process, we email you guys out a questionnaire. These were our last year pricing, but we're still doing it this year, $17.95 for a single person's trust and $21.95 for a married couple, and that's including one house, right? If you got multiple houses, it's extra. We do house calls, and we do tailor this to your circumstances, right? It's not LegalZoom where you're filling it out all by yourself and trying to figure out what's what. So I'm going to make this a little bit interactive, but I want you guys to think of estate planning as having two components, right? Most people think of it as after death, right? They're like, okay, when I die, I want to make sure that my kids get whatever the asset. But what most people miss is the during lifetime, right, pieces of this, right? So about half of the documents are focused on after death, but the other half of those documents are focused during your life, right? And I mean, personally, the during the life documents are more important to me, right? Like I'm less concerned about when I die, who gets the stuff, but what I am more concerned about is if I become incapacitated in any way, a car accident, or when I get older, dementia, senility, or Alzheimer's, that I choose the right person to put me in, you know, to make the right decisions for me, right? I always use examples like choose the power of attorney that's going to put you in the Pasadena old folks home and not the Victorville one, right? I mean, if you choose the wrong person, they're going to ship you off.
Make sure
right?
they spend your money on you guys is really what we're saying. And we think, I mean, if you do a trust, you're doing a trust primarily for your beneficiaries. Like Ryan's saying, documents like your power of attorney in particular are good for you folks during your lifetime and oftentimes help you during your lifetime.
So estate planning really has these two components, right? During life decisions, we're talking about the power of attorney, we're talking about the medical directive, and then the after death distributions. That's the trust, right? The trust, that's the easy part, really. The trust, picking the beneficiaries, it's usually the kids, that's the easy part. Picking the during the life decisions, people, that's a little trickier situation sometimes, right? You know, do you want 2 kids? Is it any of your kids, right? Who's gonna make those decisions? Anybody heard of a conservatorship? Yeah, right? So, okay, right? So it's called a guardianship when you have minors. It's called a conservatorship when we're talking about older people, okay? And so the during life decisions that I'm talking about is this power of attorney. It's the crucial piece for the during life decisions. And so there's multiple types of power of attorneys that you can give people. Immediate, current, right, power of attorney, or this type of power of attorney, which is called a spring power of attorney, right? And so let's use examples. You've got a trust, you got a power of attorney, part of it too. You don't, you don't think you do, right?
No, I don't.
If you did, who would you nominate? A kid?
That's the hard part. I don't know.
You don't know, right? Yeah, if you don't want to nominate the kid, it's harder, right? Because you have to pick somebody that's like a similar age, right, or younger than you, right? You don't want to, you know, people come in, I want to nominate my parents. You're like, they're going to be passed away by the time this kind of comes into place, right? And so let's say you did want to nominate, use it as an example, nominate your oldest child, okay, as your future power of attorney. This springing business is you would give that, it's a daughter or son who's older?
Son, right there.
Oh, right here. Okay. All right. So that now I know why
we have all the parties.
a little.
Okay.
Okay. All right. So, you know, if your mom came in, what I would suggest to her is that she gives you a springing power of attorney, which means we're not giving you any immediate power. You have 0 current power. Perfect, right? I don't want, you know, unless and until your mom gets incapacitated, right? And so your mom is nominating you ahead of time now while she has full capacity, right? No dementia, no senility, no Alzheimer's, no problems, right? But she's not giving you any current power because she doesn't need to, right? And there's no reason to, right? So it's only upon your incapacity. And so it's like a check and balance, right? You know, you are being responsible and knowing that, hey, you might get incapacitated before you die, right? But you're also not giving your son any current power, because if he gave him current power, he can sell the house. He can, right, do everything that you can do, right? And so that's kind of how we split the risk in this, right? We say, look, we're nominating my son now for this future power of attorney, right? Sometimes people will say, okay, well then what's the definition of incapacity, right? That's the next question, right? Does my son get to decide that I have dementia? No, right? But do you get to decide that you have dementia? No, either, right? It's not the lawyers either, it's a doctor, right? So it's always a medical diagnosis, right? Whether somebody has capacity or not, okay?
What happens if she does get incapacitated and let's say I don't have spring power?
Ooh, that's a fantastic question, right?
Conservatorship.
It's conservatorship. And so it goes full circle, okay? And so those are some of the worst calls that we get.
It's horrible.
We'll have these guys come in real fast. Hello, come on in.
No, welcome.
Yeah, so I'm going to use that as a perfect
That's a
example,
great
right?
question.
So maybe you don't right now have a power of attorney, right? Let's say you don't, and let's say you never get around to doing it, right? Then your son, what's your name?
John.
So I get all these calls all the time, okay, from the John. John says, my mom has dementia, right? She's walking around in the streets in her nightgown. I need to, you know, something,
Got scammed
right?
out of some money, 25 grand maybe.
Oh, yeah, I knew you were coming. I knew you were coming. and they say, I need my mom to sign power of attorney now, right? I need it. And I say, it's too late. Now she already has dementia. She's already walking around in her nightgown. The doctor's already declared her incapacitated, right? Now she can't sign.
If you don't have capacity, you can't
can't
sign a legal
sign.
document.
Right? And these people are in a lurch because they really need that power of attorney over their mom because their mom really is up to bad things and they need to protect her from herself, right? And so then they have to go to downtown LA and really sue their parent to get a conservatorship, right? And
Is that the way it works?
that's how it works. So either you have this power of attorney now, right, while you have capacity, saying somebody in the future.
Probably cheaper too.
Yes.
Those conservatorships are 10 grand to start, right? And the
They're
court,
messy.
the court has to appoint a doctor to represent your parent in court because you're suing them to take away their autonomy, right, for life, right? And then you have to annually report to the court. Every year that you have that conservatorship over your parent, you have to annually report that you're not stealing the money, right? So this power of attorney is overlooked for people, right? It's so easy to have this in place now, and it's such a problem right after. And I wish I could do these power of attorneys for these people, right? You know, that their parents have dementia or somehow incapacitated already, but I can't. There's just no way. You're not going to get a notary to sign off, right? You're not going to get a lawyer to sign off, right? But the people need it. Okay,
And we get these calls at least 2 a week, 2 times. And we feel for the kids because, Jonathan, you need power of attorney, but we can't legally have a person that's incapacitated sign a legal document.
Yes, ma'am.
So do the spring power of attorneys have a time limit or an expiration?
No, right? And so most of our clients, let's say that they're in their 50s or 60s, and these power of attorneys that they're signing are not going to get quote unquote sprung for 20 years, right? For 20 years. And, but no, there's no expiration, right?
Yes,
Good.
ma'am.
So I have a question. If I were to appoint one of my children to be a spring power of attorney, and, you know, for 20 years later, I get pissed off at them, I don't want them to.
You can always change it as long as you have capacity,
Yes.
right? But once you lose capacity, now it's locked, right? So everything is changeable as long as you have capacity, right? But you can't change it once you get dementia because you have dementia.
You could change your trust, your power of attorney, your
Right.
medical directives.
And look, frankly, there's a lot of people that get dementia and don't admit that they have dementia, and then they try to switch all kinds of stuff. But now they're not in charge of it anymore, right? The doctors have stepped in and nominated those kids.
So you mentioned that when you go to court to ask for,
The conservatorship.
so the court appoints a doctor, right? So
Yep.
it has to be somebody neutral, basically.
Yeah, exactly.
So what do they go through, or they have to just prove that they're already like?
Yeah, exactly.
Okay.
Yeah, it's a court supervised process instead of solely a doctor supervised process, right? The power of attorney makes everything easy. It's just one independent doctor signs a incapacity declaration, right? And we tell our clients, look, those doctors are not going to sign those things easily, right?
it's under penalty of perjury.
They are going to err on the side of leaving you with capacity, right? You could go in there drooling, and of course your kids think you're incapacitated, but you're not, right? So you're allowed to make decisions your kids don't like. You're allowed to squander your money. You're allowed to make all kinds of bad decisions, right? That's not the definition of incapacity. It's a completely next level, right? And some people lose capacity and regain capacity, right? Maybe car accident, you're in a coma for 6 months, and your kid had to step up, and then you regain capacity, and now they're not that power of attorney anymore, right? But yeah, you can always change it as long as you have capacity.
Can you name 2 people?
Absolutely, right? We always suggest not to, right?
Not but having one person and then maybe another person
As a
listed.
backup, right? So we always think one child and then another child or whoever we're nominating as the second, right? We'll talk about in the trustee, but is just kind of a nightmare all the way around, right? It's 2 people now that have to decide on everything, and they're not going to agree on everything, right? And so we counsel our clients very heavily. Please don't nominate 2 or 3 of your kids all as the same.
Can you stipulate, like, for example, like succession, let's say the main one, something happens, because anybody, something happens. So basically, let's say it's me first and then my brother.
Absolutely.
Yeah.
Okay, something happens to me, then my brother takes over.
Absolutely. We always want redundancy, backups, right? But that's different than right? Co is too many cooks in the kitchen, right? Especially if you
Yes,
nominate
yes.
siblings as co, forget about it. They're gonna fight.
Oh, yeah, my brother and I wouldn't.
Yeah, exactly, right?
Was it, if talking about like here, we have the first and then the backup first. Is it possible for the first, like, let's say, give up the power of attorney?
Absolutely, yes,
sir.
absolutely, right? So there's two ways it goes from the first to the second, right? That person dies or they resign, right? We can't make them fulfill these roles, and that's why we have backups for everything, right?
Is there a process or can it be internally
They just-
agreement, or they'll have to go back to court? And
No. Well, there is no court if you have power of attorney.
Oh,
It's
okay.
only court if you don't do this stuff,
Okay, I got you.
right? And so it's all internal as long as you have the power of attorney. The one sibling would just sign a resignation letter, and now the next sibling would be in charge, and they have to bring that whole thing to, like, it's for bank accounts, for managing stuff like this, right? And so the bank would say, well, how come the first person isn't acting, right? And so that's why you'd have to show the resignation letter, right, or a death certificate or something that person's not acting, and now that's why the second person is acting. Make sense? Yeah. I love these questions about power of attorney. Power of attorney is one of my more favorite. Okay, so power of attorney is for financial decisions, right? That's quite broad. This medical directive is for discretely medical decisions, right? So think of medical as like 5% of the decisions, the other 95% is that power of attorney, okay? So this advanced medical directive nominee is solely making decisions like, do you want a DNR or not? You guys know what a DNR, do not resuscitate, colloquially called that, right? Spanish speakers, no maquinas. No, we hear that all day, right? No maquinas, right? Yeah, exactly. Other decisions you'll be making on the medical directive are, do you want burial cremation? Are you an organ donor? But really what you're doing is you're nominating your kids. I mean, I'm going to use that as an example. It doesn't have to be your kids, but you're nominating somebody to, if you cannot speak on your own behalf, to make medical decisions for you. It's really follow your instructions, right?
It's making that one big decision, choice to prolong life, choice not to prolong life. So your kids or whoever you name as your agent doesn't have to make that decision for you. We told our mom, just make that decision beforehand. We'll follow through with whatever your wishes are, but don't make us second guess what your wishes may have been. And then the burial versus cremation as well.
Questions on medical directives? Simpler.
I have one.
Yes, ma'am.
So, the do not resuscitate, okay, the DNR, if I say, no, prolong my life, I want to try fighting,
Mhm.
Yeah.
just because I
Sure.
Yeah.
pneumonia, don't just say,
Mhm.
get done with her. So if I say prolong my life and my kid says, you know what, she's lived a good life, just let her go now.
Yeah.
Does she still have to follow my
Probably,
wishes, or,
probably not, right?
because she could say, nah, just.
Well, because she'll probably just not even bring this document, with, or say, right? So the way we kind of answer these type of
Choose
questions, right? Huh?
Choose wisely.
Yes, ma'am. Yep.
That's exactly the answer.
Matters who you pick.
We're like,
For
don't pick
medical-
somebody you think's not going to fulfill your obligations. And we have kids that come with their parents and they tell Mom, I'm not doing that. I don't care what you say, I'm not gonna do that. I'm doing the opposite. And we
So
look at
they
the
choose-
client and say, are you sure you want to pick this person?
Yeah.
Right? I mean, you're listening to your kid. I'm not going to get involved, but you're choosing this person, and they're telling you they're not going to honor your wishes.
So you
Right.
may choose somebody else, a friend, a sibling, somebody that is going to follow through with your wishes and not
This
tear it
usually
up
comes into
after.
play with like Jehovah's Witnesses and stuff like this. So we have people that they want no resuscitation, and their kids are going to try to resuscitate them, and so they choose like a church member or somebody who will actually not give them any intervention, right? But yeah, I mean, if there's any question about whether these people are going to fulfill, we say, don't choose. Let's pick a third
Let's
party.
find somebody else.
Find
if
somebody
we can.
else, right? But sometimes it's hard, right? But yeah, no, that's a really good question, right? Because these are private documents for the most part, right? And so you're relying on these fiduciaries. That's what they are, right? They are your chosen fiduciaries, and you're relying on them to a large extent.
Are you notified when you're given power of attorney beforehand? So like the screen
Yeah.
is what you're.
No.
Is your idea then?
So no, it's not. It's only the person who's giving the power of attorney that needs to sign. The person who's receiving it does not need to be notified or sign or
So it'd be a
anything.
total surprise then.
Yeah,
Yeah.
but that's why you don't have to do it. right? So we don't need to notify you because you could just say no, right? Even if you said yes, you wouldn't be obligated. You could always just say no. We can't make you do stuff. So even if you signed, I promise to be powered, that doesn't mean anything, right?
Can you do this with a minor too?
No.
No.
I mean, some people do that. Kids who are 16, right? And we're like, they're going to be adults very soon, so we're willing to risk it. But I wouldn't nominate like a 4-year-old or something, because
No. I'm talking about. Sorry, my apologies. Like if I want to give power, one of my youngest son, I need to give power to his sister. She's older, so it's me or her. Can I do
Wait,
that or no?
wait,
Basically,
wait.
so my son, she's gonna be in charge of him certain things for a bit.
Is he guardian or is he a minor?
Yeah, he's.
So this is guardianship documents, right? Right. So you would be saying, if I die, this is who I want to be the guardian of my minor child. Absolutely, right? It's the opposite end of the spectrum, right? If you're old, it's guardianship. If you're young, it's guardian. Or if you're young, it's guardian. If you're old, it's conservatorship. Okay. Yeah. Good questions. Okay, let's get into trust now, right? We talked about power of attorney, we talked about medical directive, those during life, right? That's the during life stuff. Now let's talk about the after you die stuff, okay? I kind of hinted at this answer already, but I promise you guys, trusts are about one thing and one thing only, right? People think that they're about a lot of things, but they are not. They really only solve one problem. I wish they solved more problems. It would be easier for me to sell these things, right? But they don't. They solve one problem, but it's a big problem, right? Anybody guess? Just what's the
Who gets their money, the house, or whatever you have?
The house. The house.
The house. Not really the money. The house, right? The house. This is the problem. People don't think of this as a problem.
How do I
right?
get my house to my children when I die?
Right? People kind of think that this is like an easy answer, right? Some people are just like, oh, it just happens, right? Don't they?
They just
right? A lot of
inherit it.
people, right? Guys especially, I kind of think I would have thought that, right? Oh, it just doesn't just kind of automatically happen, right? Don't they just kind of have to sign a couple pieces of paper and they get it? No, right? So this is the whole reason, this is the whole shebang why trusts were created, to solve this one problem. How do I get my house to my kids? And so there ends up being, and I know we have some real estate people in the house, truly only 3 ways to solve this problem of how do I get my house to my kids, okay? So option 1 is you do nothing and your kids inherit the house in probate, right? If you do nothing, your kids will inherit the house. It will eventually go to them, right? It's not gonna go to your cousins or your neighbor. It will go to your heirs, right? But how much is it gonna cost for them to actually get that house, right? So option 1 of getting your house to your kids is you do nothing and your kids will inherit it through court, okay? Option 2 is you add your kids on title, right? So you could just go to the county recorder, you live in LA County, right? Go to Norwalk, right? And for $100, you could add whoever you want on title, right? And that is a solution. It's gonna come with some problems that we're gonna talk about later, right? But it does quasi solve that problem of how do I get my house to my kids? Because if you add them on title and you die, the house will go to them, right? We're gonna talk about why that's still not a good reason or a good way to do it, but it is a viable method. And number 3 is the trust, right? So it's just those 3, right? Just those 3 ways, that's it, okay? Anybody have any guesses on what the most common of these 3 methodologies is? Like what do most people choose?
Grant deed or
Grant deed, probate, right? Number 1, yeah. It ends up being the grant deed.
Number 2.
It ends up being number.
We talked about Hispanics are big on that.
It ends up being number 2. So why do I think it's not number 1, right? Because I think that
Not a
people.
bad guess.
It's not a bad guess.
It's a good guess.
It's the number 2 guess.
Yes,
It's
yes.
the number 2, right? It's the number 2 most common, right? But I think that most people don't do nothing because they want to do the right thing, right? Most people, they would like to get their house to their kids as easy as possible, right? They don't. Most people are like, I don't want to leave my kids a bag of hooks and just leave them, to their own devices. So most people want to do something proactive, right? But they just don't know what exactly to do. So most people
Good intentions.
Good intentions, and they go down to the county recorder and they add Jimmy and Johnny and Jamie on title, okay? So I would say, this is like, let's say this is 50% of people add their kids on title. It's called a will substitute. It's also called a poor man's will, right? It works. It does. It gets them on title. We're going to talk about those other horrible ramifications, but it does work for a little bit. So 50% grant deed. I would say another 30% of people do nothing, and then about 20% of people do trust, give or take. Right? So you guys are already in like the 20% just thinking about doing trust, because most people don't.
Yeah.
Most people don't do it. Now, is that number 20%, is that true for rich people? No, rich people, 95% of them do it. And if you learn from mommy and daddy to do a trust, you're most likely to do a trust, right? So who does the grant deed? Poor people, right? Who they don't want to spend the $2,000 to do the trust, and so they know they can do it for $100 on the county recorder, and they don't know the other ramifications, and which we're going to really drill down on in a minute. Okay? Any questions about these three? Anybody come up with any other ways?
If you ever do, just let us know. I'd love to hear one.
I actually had a client,
Mm-hmm.
husband passed away. She went to the recorder's office. She filed death affidavit, submitted the death certificate, and she thought she was done.
Mm-hmm.
It was cool.
Mm-hmm.
Property's in her name.
Mm-hmm.
We go to sell the property.
Yeah.
She's gonna do probate.
Go to probate. Yep.
It's fun.
Yeah.
She's going to have to do
It's
probate.
no way title
That's
signing. off on
that's when
anything.
all the realtors learn that title is God. Title is more
everything.
important than us lawyers, right? They don't care what the lawyers say.
We
they
have
care
to
what
get you through title if we can.
title companies, because they're indemnifying a $800,000 transaction, and they're not.
Gonna insure it.
Yeah, they're not going to insure that thing
nope.
unless that chain is
Clean.
right. Well, and so it's usually title during the sale where the people find out the bad news, right? And it goes back to my beginning. Most people just think it just kind of happens, right? Like of course I should get the house, and maybe they're right. It probably is going to go 100% to the spouse, but it's going to cost 4%. It's going to have to go through probate, right? Let's talk about probate for a minute. Most people think that when they go through probate, they're losing the money to the IRS. Right? That's in most people's mind. They're
comes
like,
up
I
quite
don't want
often.
to. I don't want my kids to lose the money to the IRS. I need to do these probates, right? Doris, come on in for the cold, man. Yep. Now, I don't know if it's better or worse, right? But it's not the IRS that your kids are losing the money to. It's the lawyers.
It's
The
us.
IRS doesn't get 4%.
Well, let's
We
be honest,
get
it goes
4%.
to us. Yep.
Right? Because the lawyers wrote the statute. We wrote the laws. And so we said, hey, what do we want to give ourselves? Well, let's give ourselves 4%, right, of the value. Right? And that's gross value. It doesn't matter that your house the market's $1 million, but you owe $800,000. I get 4% on $1 million. I don't care that you owe $800,000, right? And so, almost everybody thinks that they're losing the money to the IRS, right? But I think it's even worse. I'd rather lose my money to the IRS than the lawyers, personally, right? I mean, either way, you're going to lose a little bit, but it's not the IRS that's getting you. It's the vultures, right? It's the blood-sucking lawyers. Well, we are sharks.
2 years dealing with us too. I mean, you're not getting out of probate for 18 months to 2 years is the minimum amount.
And
you're gonna
if
be
there's a
for.
mortgage, you're paying the mortgage the whole time. You're paying electrical. You don't get that money until the end of 2 years, right? It's just kind of a bureaucratic. Think of probate as just a clearinghouse. It's just a bureaucratic, judge-appointed process where you transfer a house to the spouse or to the kids, but it just goes through the lawyers who get 4%. It's a hefty thing. I mean, I tell some of my clients, look, these trusts sell themselves. Do the trust for $2,000, or I'll make $50,000 on you when you die. Either way, right? You're coming through me, right? Either way, right? So these three ways, right? You do nothing and it goes through probate, and then you lose 4%. Okay, so let's kind of use an example: a $500,000 house, 4%. What's that, like 20K, right? And so you do nothing and you lose 20K, okay, to the lawyers, which that's not the end of the world, right? You do the trust, and you pay $2,000, so you're already saving 18 right off the bat already. And that's not you who's saving though, right? It's your kids.
It's your beneficiaries.
It's your kids who are saving. So it's not a real direct save.
So should I charge the kids?
You should.
Yeah.
You should make
If your
those
kids
guys.
are adults, they should be paying.
You just gave me a really good idea.
Except you. Except you.
Well, because you're teetering on trustee anyway. We're not sure if we're having. Yeah, I know exactly.
I thought
Yeah.
about that too.
Yeah, I know.
She asked the question.
How can I resign? That's what I heard. That's what I heard.
Do I have to fulfill this role?
Exactly.
On the POA, not as the trustee.
Yes,
Yeah, no, you're right. You're right.
Fair.
You're right.
That's
You're
fair.
right.
Yes.
You're right. You're right. Right. So you do nothing and you lose 4% to the lawyers. Okay. You do the trust. You lose $2,000 to the lawyers. Okay. What do you lose on the grant deed? Okay. And so that's what we're going to talk about, right? We know it costs only $100 to do it at the county recorder. So that's not what you're losing. You're losing something else. Yeah, no, actually it's not.
That's yearly,
right?
yeah.
So, and I already gave away the punch that this was the primary, but for some crazy reason, this is what people do. People add their kids on title, okay? It's just like intuitively people want to do it. I don't know. People come and I just want to add my kid. I don't know, you know. And I ask people like, would you add your kid on your car note? And you're like, hell no, I wouldn't add my kid on my car
But on
or
your
something.
house?
But you're like, yeah, I want to add them on the title to my house. And it really is just a will substitute, right? Because the people aren't thinking that they're giving the house to their kids now. The people are thinking in their mind, I'm giving it to them when I die. But they're not. They're adding them on title now, right?
So if they get in a car accident.
Oh, now we're talking
Yes.
about car accident,
They get
divorce,
married and divorced.
right?
Yes.
Yeah.
They're
now
a co-owner with you now. Yes.
yes. So now
Judgments,
I have
liens.
a realtor and I'm going through, the daughter wants to take the house away from the mom.
Yep.
Yeah.
And I mean, I think I've seen it all. I've been in the industry 20 years, right? So.
We see that all the time.
We've seen a number of adult children who their parent granted them on title and they wanted them to sign back and they said, no possible way, I'm an owner
It's
too.
usually a surgery. Like the example, or the guy was going into surgery, so he adds his only son on real fast, gets better, and says, "Okay, give it back to me." And the kid goes, "What do you mean?"
My house?
And so the dad had to refinance, pay out his son $300,000 so he could get the house back.
So my client wants to sell, but I won't get the listing. The daughter will sign my listing agreement only if she gets half of the equity.
Sure. Sure. Right.
You know, it's a fact. It's a
Yep.
reality where I'm leaving because I'm gonna get the listing.
Yeah, and I'll bet your client wasn't thinking, one, that he was giving a current gift, and two, they're thinking that, of course, if they want it back, their kid will give it back.
Yes,
It's trust.
yes,
Yeah,
it is trust.
It is. It is. So, like you said, right? These are these.
Divorce, deaths, accidents.
There is no reassessment when you add somebody?
No. No. So
It's done.
that's why it's done, right? Because
Yep.
you're
Quick
allowed
answer,
to add people on your title without getting reassessed. You only get reassessed when that original person comes off title. So they'll let you add people all day without reassessing you. It's as soon as that original person comes off, that's when they reassess, right? I kind of wish they would reassess because it would stop people from
Yeah.
doing this.
We wish they'd make you go through a course if you were going to add people on title, letting you know what the ramifications are. Now, if they're a co-owner with you, they don't have to sign title back over to you if they don't want to.
So it's pretty, so once, let's say the original person dies and it goes to the,
That's when it gets. That,
Oh, yeah.
he can take the death certificate to the county records and that's fine, it's in his name.
it is in his name, right?
And there's nothing else to,
Well,
at that time, it could be reassessed.
It
I understand.
will.
Well, yeah. The big problem about the grant deed option is not property taxes, and that's what you're talking about, reassessment, property taxes.
Right.
The real problem is capital gains taxes, right? Because what do the kids usually do when they inherit a house? They sell it,
They sell that.
right? The more beneficiaries, the more likely they're going to sell it, right? I mean, if 5 people inherit a house, how are they going to pay each other out, right? Was it like one person going to refinance and pay out 4 people? Good luck, right? And so the more beneficiaries, the more likely the house is going to get sold. If it's one person, maybe they keep it, okay? So, like you said, sir, first reason, right, why the grant deed, right, the primary way people do this, why it's the worst of all the three, right? And the first reason is why it's bad for the owner of the house, right? Because if your kid gets a divorce, your kid gets a bankruptcy, your kid, gets in a car accident, they are going to come take your house because your kid is that partial owner. Okay, so that's a reason for you guys why you don't want to grant deed your kids. Okay, I'm going to show you also why the kids don't want to get grant deeded. This is your example, right? The parents lose control of ownership, right? They say, please give it back to me, and the kid goes, no. Right now it's a partition
Can't
agreement.
even do the listing agreement, right? Yeah.
Right, exactly. You're going to give her 50%. There's no way around it, right? There's just no way. This third one is the big one, though, okay? And this is a little bit more complicated, but it's also by far, I think, the most important piece of it, okay? And so I have that one math problem that I told you about earlier that we're gonna use. But the worst problem is the kids inherit the parents' purchase price. Okay, so let's talk about capital gains for a minute. People, you guys know what capital gains? Anybody never heard of it? Some of you guys, right? So capital gains is based on what you purchased the house for versus what you sold it for, right? And that appreciation is the capital gain, right, on the house. And so, you guys are the house owners, so you guys understand what your purchase price was, right? You purchased your house for $100,000, and if you sold it for $800,000, you had $700,000 appreciation. It's kind of simple, right? What do you think the kids' purchase price is if you add them on title? It's kind of a harder question.
What was that?
So if you go down to the county recorder and add your daughter on title, what's her purchase price? I mean,
Wouldn't it be what I purchased it for?
100%.
Okay, so I have a question. What about a
Quick claim
same
deed?
thing.
It's just a grant deed, all the same.
Yeah.
It is,
Mhm.
Yeah.
it is the same?
Yeah.
So if you quit claimed it to your fictitious daughter, yes, her purchase price would be
Your purchase price.
But that's not taking the parents' name off the house, that's just.
No, they'd both be on still.
Yeah.
you'd still-
So now back to they said earlier, someone said earlier, if the parents someone passes away,
Mhm.
the parent's name's still on there, it doesn't belong to the child they put on there, correct?
It would go to
does.
the child.
No, it does. It
The
goes.
parent
It
would come
goes.
off, yeah.
It goes,
Okay.
right?
Mhm.
But
Added the name.
yeah, because you added the name, right? But
As a
so
joint
so does your purchase price. That's the real problem, right? Is that your kid, your child, they do not want to inherit your purchase price, right? So
Properties in California have appreciated a lot. And
And so-
hopefully all of you folks purchased for a low price and it's appreciated during your ownership.
I'm going to give an example, and it's the same house, it's the same purchase price, it's the same everything, except option one, they grant deeded it, and option two, they did a living trust. Okay, I have red light, green light. Red light, don't do it.
The
Green
only
light,
math.
right? Okay, so it's the same house, right? So you purchased it for $50,000 in 1950. Now it's worth $1 million. Okay, so on both of them, right? Both of them, 1950, right? It's worth $1 million now. Okay. If you grant deed your kids, they inherit your purchase price, right? So that $50,000 purchase price. Okay, and so you add your kid, you die, they get it, the house 100% because you added them. That works, right? But then when they sell it, right? What did they have? They had $950,000 of appreciation, right? So they inherited your purchase price for $50,000 and they sold it for $1 million, right? That's $950,000 of appreciation. Capital gains is like, I usually say it's like 20 to 33%. Our client today was like, I pay 51%, right? So it's long-term versus short-term capital gains, but it's at least 30%, okay? So option one, you grant deeded your kid on title, and when your kid sells the house, in this example, they are paying $266,000 in capital gains
To the IRS.
to the IRS because you added them on title, okay? Same scenario, same house, right? $50,000 purchase price, now it's worth $1 million. Instead of grant deeding it to your kids, they inherit it. It doesn't matter if it's in a trust or probate, as long as they inherit it, right? As long as you didn't give them that house during your lifetime, they get what's called a step up in tax basis. So instead of inheriting your $50,000 purchase price, they inherit the house at its present market value when you pass away for $1 million. So they sell it and now they pay zero.
If they sell it at $1 million.
At $1 million.
Worth $1 million.
If it appreciated during
They're paying
their
capital gains
ownership,
on
they
the
pay
200,000, which is a great problem to have because now it's even worth more.
So then this is only a problem if the children decide to sell the house, then, correct?
Yep.
More often-
Yes,
Yep,
yes, yep. It is not a problem if you hold on to
But
the
literally,
house.
if you granted them off, they can't sell the house.
Yeah.
It's locked because they're going to pay $250,000 in taxes. They'd rather just keep it even though if they don't want to keep it, right? So let's kind of drill down on this, right? Same everything, right? And so my brother said earlier that we wish the county recorder would not let people do this, right? I mean, this is the same house, and one method cost the kids $250,000 and the other one cost the kids zero. Who does this? Poor people. They lose all their money. Who does this? Rich people. They keep all their money, right? I mean, the county recorder's playing gotcha on poor people, right? Because the county recorder knows you shouldn't be deeding your kid on title. They know the tax ramifications. They should, like Rory said earlier, make you take a counseling class, something. Like, do you know you're costing your kids $250,000 in taxes when you could be costing them zero, right?
Well, that doesn't help them.
Say
That doesn't help them, though.
No.
no.
It doesn't help our government make more money. We wish they would help people out, though.
Yeah, but I mean, from our vantage point, this little scenario, this step up in tax basis that you get from inheriting an asset versus inheriting the purchase price of your parents, if you get gifted, this is the whole ball game, right? This is why, from our point of view, why you guys are here. This is why, you know, if your kids knew better and you wanted to add them on title, they'd say, hell no, don't add me on title. You want to try to cost me $250,000 when I could just wait until you die and get it for zero, right? Right?
So yeah, if your mom offers, say, nope, I'm not taking it. I'll take it after you pass, which hopefully isn't for a long time.
Question?
So, when when you're in a trust and you pass away, you are supposed to file first of all, you need to get an appraisal, right? For the
The
time of
house.
death valuation. But aren't you, while you have a trust, you go to your lawyer, don't they have to file and I forget the term, I always forget the term, the death of the
Yeah.
trustee to add the successor trustees, I forget what it's called.
Yeah, it's an affidavit of death as a trustee.
Okay,
Yep.
but does that trigger a reassessment of the property?
Well, see, I'm talking about capital gains, and you're talking about
Okay.
property
got it.
tax.
Yeah,
Okay.
yearly
Right?
and then
And so there's
Got it.
two different types of taxes that you have to worry about. These are the two,
Good. Yeah,
right?
you're on the
And
right.
so you worry about reassessment and property tax if you're going to hold on to the house,
Okay.
and you worry about capital gains if you're going to sell the house.
Okay, perfect.
Right? And so, now I'll talk about this for a second real fast. So currently, Prop 19, which was recently passed in California that undid Prop 58. Okay, so Prop 19 says that your kids can retain your current property tax if it's your primary residence and they retain the house as their primary residence. So they really carved down this parent-to-child tax transfer to like a keyhole of an exception.
One
right?
house
It
and they
used
have
to
to live
be
in it.
your kids could inherit 20 houses and they could keep the low property tax on all 20 of them, right? But now it has to be your parents' primary residence and you have to move in there and make it your primary residence. If you move in there for a year and then you move out, they're going to reassess as soon as you move out to present market value, right? So most likely the house is going to get reassessed, right, for property tax reasons, okay? Unless it's a primary and your child is retaining it as
1-to-1.
their primary,
Let's vote Prop 19 out too.
right? Questions on this piece?
When is that effective?
3 years ago.
Yeah. So up until then, yeah, you could leave 50 houses to your kids. They could use them as investment, rentals, and no property tax reassessment. But now with Prop 19.
Hey, it's the realtors. You guys, Carr passed it. $30 million. Carr put it on the ballot. Carr put it again on the ballot. Carr is California Association of Realtors, right? They don't want your kids to keep the house. They want you to have to sell it. It's easy, right? And so, now most houses get sold, right? Because of the property tax, right? Because I mean, you guys are probably paying 2, 3, 4,000, and as soon as it gets reassessed, it's going to be 10,000 a year on most people's properties, right? And so, unless you're cash flowing it and renting it out for a lot of money, it's hard to pay that increased property tax. But yeah, those are the two taxes that we're worried about. Property, right? Property tax, holding on to it. Capital gains, selling it, right?
So if you said like a trust is for property.
Mm-hmm.
Does a trust also, so let's say that your parents left you a trust and they've left you money and it's only in your name and you have a husband and wife on the other. Does a trust, does a will, or does a trust make it able to, let's say you died before the trust was handed out.
So you're the beneficiary of a trust right now.
So let's say like she was the beneficiary of a trust and her name only. I'm married to her and she dies before the trust was funded.
Yeah, okay.
And and it's funded in her name only.
Mm-hmm.
Does
Yeah.
a trust protect that if you set it up? Or
If I set up a
If
trust.
you set up a benefit.
No, because you haven't inherited anything. Because you haven't inherited anything until that other trust is done, right? So if you died before you inherited anything, you can't leave it because you don't own it. Right? That makes sense?
It has
Right?
to
So
legally vest.
yeah, it has to be vested in you, and it can't vest in you if that trust is still right. I mean, it's a beneficiary of your parents. Whose trust would it be? Parents, right? Yeah. So if you died before your dad died, it never vested, and so you can't leave it to somebody else.
he's died. So
But.
They're
so-
receiving current payments.
So what happens is my dad was, he did not have it. Most trusts will say, I leave it to my children, blah, blah, blah. And if they pass away,
It
their
goes to the
portion would go to
grandkids.
their issue, their spouse or kids. My dad didn't believe in that. So if I should happen to pass away in the next year or so before the trust is funded.
But how it's his trust, but it's funded. How's it not funded?
He died.
Yeah, so it's funded, and he died, so it already vested.
Right, but let's say, but we have not settled it. We have properties to sell.
Oh, okay, but it's vested in you. It
Yeah.
vested, even though you haven't done the paperwork yet.
When he
As soon as he
passed.
passed away, you legally
You were
became the
legally
owner.
dead.
But if I were to pass away now,
It already vested. So
does he on him, but it doesn't
You need
say
to have something in place saying that
That's
saying
what
that
he's
he-
your
yes.
spouse
That's the
inherits.
question
Yes,
he
so
yes.
does a
asked.
trust do that?
Yes.
So if I go get my own
It
trust
would.
in my own name.
Yes,
Okay, so
yes.
And my assets
Yes.
would then go
Yes.
into my name.
You would say your spouse is to inherit
yeah,
if you
exactly.
pass away.
But
and
hurry
vice
up and
versa.
settle your parents' trust and get those assets into your name,
Yeah,
right? Because the longer, the you're at risk, the longer you take,
right.
right? 2
Right, so
years.
you want it to go as fast as possible.
Yeah, and usually these things take at least a year, right? So if you guys are under a year, you guys are doing
You're doing
good.
okay,
If you guys are
yeah.
closer to 3 years, you guys are taking too long.
It's only been 40 days.
Oh, well, you guys
Oh,
are,
you guys are doing okay.
Well, they also have,
So it's,
it's a code.
oh, yeah,
okay.
yeah.
yeah, so it's not.
I know. Just don't pass it forward. So everybody who saw their parents do code, they wanted to do code. I don't know why. I'm like, don't follow
Well,
your
you
parents'
know,
horrible
it-
example. You don't want
It
code.
used to be the old way, and it also was kind of a checks and balance. That's what the thinking was.
I always think it's just selfish parents that don't want to make a decision because they know they're leaving their kids like in the lurch. They're like, oh, I know my kids don't get along, but I'm going to force them to. You're like, oh my gosh, that's what a horrible idea, right?
That wasn't the situation until.
It didn't seem.
It was all good before that, yes, and you don't want that to happen either. Things are copacetic, and then you make them work together, and now they don't get along. That's horrible.
Yep.
The step-up basis on the, okay,
Capital gains. Yep.
on the capital gains. So the living trust is recorded? Let's say I set up a living trust right now.
Yep.
And it's recorded, so that means that it's, the step-up would be as of the time that I record?
No. It's after the time you died. Your kids would inherit a step up.
Okay.
Right,
So it
as a-
doesn't matter when you
No.
record the living trust?
No.
Okay.
Because the living trust doesn't do anything. It doesn't really change ownership. It's you own your trust and you were on it before. right? But the step up would be, yeah,
At that time.
at the time of your death. That's when they get this date of death
It gets
evaluation. Somebody said it
appraised.
earlier. Yeah, right. Yeah, they go to the realtor and they get the free appraisal. Right, they do the comps and they say, okay, it's worth 900,000. You file that with the IRS with your next, right, and then you get a step up, full step up. So,
So you can do a CMA, a current market analysis?
We do them. We do them
For
all the time.
realtors too.
Or
As
you don't have to
realtors.
get a true appraisal then?
No,
Okay.
no.
the IRS doesn't really care, right? I mean, as long as the appraisal's not crazily off, right? And I mean, they're going to usually use something. If you sell it right away, they're going to use that because that's usually the best estimate of a current
It's quite
sale.
accurate,
It's
yeah.
the best indication of market value. It's really no better, right? So this is one of the more complicated pieces, right? Why is this true? I don't know. So if people do just a will, okay, you still go to probate. Okay, the only way to avoid probate is the trust. And I kind of vacillate between the best ways to explain this, right? But think of the trust as it's more of like a Inc. or an LLC. It exists fictitiously, right? And because it exists fictitiously, it can own things. The trust can own your house. It could own a bank account. It could own a car. Okay. Think of the will as a will can't own things, right? A will can dispose of things. I could say in my will, I leave my coffee to you, right? But I can't. My will can't own my coffee, but my trust could, because my trust is like a corporation, like an LLC. It can own things, right? And so that's one way to think of the difference between a will and a trust. Another way to think of this is, like I did at the beginning, I told you guys the estate plan is power of attorney, medical directive, will, and living trust, right? So we're always going to be doing a will also. We're never going to do just a living trust for you guys. We're going to do a will also. Now the wills are called pour over wills. And what that means is the will is a backup. The trust is the primary document. It owns the house, right? But let's say for some reason you took the house out of the trust. A refinance is one way, right? I, as your lawyer, you come in, I fund the trust, I file the grant deed, it owns your house, and in 10 years you refinance, and the lender says, hey, I want you to take the house out of the trust and sign the refinance personally, and then go back to the lawyer and put it back in the trust. People die, and people don't put it back in the trust. People do stuff, right, like that. And so the will literally pours that asset back into the trust. So the will is solely a backup document, and it's in case you guys as the client switch around title after I put the house into the trust. It's usually a refinance. It could be also an additional purchased house, right?
Most common one is a refi.
It's
Yeah.
by far the most common is the
90%
refinance,
or higher. Yep.
right?
So
You
it
know,
goes from trust to will to trust again.
yeah.
Yeah.
But anytime you're dealing with this will, he's got to have some type of court intervention, right? The only way to avoid everything is the trust. It's a little tricky on that part. Okay, so I already told you guys that only 30% of people do the trust. I mean, it's 20, 30, something like that, but it changes, right? So, like, in the really nice neighborhoods, I mean, I look up title on everybody's house. I have title searching software. I just go, you. I know everybody has a trust, right? Because they learned how to do it. It's all just information, right? And I know in some of the other neighborhoods, nobody's going to have a trust. And I'm like, oh my gosh, these are, that's who loses the generational wealth, right? If you lose $250,000 in capital gains taxes out of $500,000, you lost half your money, right? For no reason, right? Okay, so this is probably an understatement, but probate's awful. It's even awful for the lawyers, right? I mean, I don't like them either, right? It's just like a 18-month court-supervised process where the judge is just in our business supervising everything that we do, right? And it's tedious, it's expensive. My clients don't love me. They want the house. They want the money. They're like
want
18 months. I
everything
tell them,
quick.
when the realtor tells them that they can't sell the house and they have to wait for 6, you know how mad they are, right? So they're not loving me either, right? So it's not the best situation.
We'll take the money though. we take the money, but it's not the best situation.
Right? But the $40,000 average, I mean, that's just kind of average of the market value of people, but it's 4%, right? It's statutorily written. And it's not true in every state. Arizona doesn't have a very bad probate process. Nevada doesn't. California has a very onerous process, right? We have a significantly more onerous process than a lot of other states.
But it's not even that. I mean, it's that, Ryan, but for me, it's the upkeep, right?
Well, yeah.
The
Well,
whole time you have to be
especially
paying the mortgage.
especially if there's a mortgage,
Yeah.
you got to pay the whole time, right? And you have no access to funds necessarily, right? So somebody's fronting that money for to keep the electricity, to keep the gardeners coming, right? And they're not going to get that money until the end of 18 months. It's a long time to wait. I mean, I don't get paid either till the end, but right, that's okay for me. But yeah,
If they don't pay, can you go into foreclosure?
absolutely.
Oh, yes, yeah.
Absolutely,
Yeah,
right? That's a
definitely.
great question, right? So the probate
It will
process
go.
does not stop foreclosure, right? There's nothing to stop a foreclosure really except pay.
Bankruptcy.
Yeah, right? But
But they're not on title.
Oh, I see.
That's
Whoever
Yeah.
title.
Who
Okay.
would, so who
That's the
pays?
problem.
one of the kids,
The beneficiaries.
So the beneficiary. So one of
They're the only people that have an incentive.
hopefully.
If not, yeah, nobody.
Wow. That was one of the reasons why we did it, thinking about that.
I had a house in Riverside, Temecula courthouse. It got foreclosed on in the middle of the probate, and I just had to shut it down.
Not
It was
enough
just a
equity.
big L for me. I had to, I ate the money,
More wolves
Yeah.
in foreclosure
Yeah.
and probate.
Yeah, they foreclosed in the middle of it. The house was already underwater. We were trying to get through before they foreclosed because I'm talking to the lender, right? But no, it doesn't stop it, right? I know it's horrible, And you think of probate is a place where the house goes into and you have to pay the creditors, right? That's really what probate is. It's an opportunity for everybody who says you owe them money to submit claims, like Medi-Cal, like the mortgage, like
Credit
Victoria's
card
Secret, credit
companies.
cards, right?
And all the mail
Everybody,
comes to us. We get all the credit claims.
right? And you have to pay those, right? But think about it, if you do this trust, you don't have to pay any of that stuff because they just send those bills to your trustee and they're like, screw that, I don't have to do it.
It's like a bankruptcy.
It's exactly like
exactly. Yep. Everybody comes out of the woodworks with their hand
exactly.
out.
It's what are those here? I always forget the number. The 403B hearing or whatever.
341A.
341A hearing, bankruptcy
I
hearing,
did
right?
bankruptcies in a prior
Yeah. But it's the same. It's the
During
same.
law school, I worked for a bankruptcy judge.
It's the same thing, right? And I mean, if you owed if you got Medi-Cal, right? You probably owe
They're going to
$250,000
submit a bill.
easily, right? And that's probably the kid and caboodle. There probably isn't any money left over.
I have a question on that. I have a client, well, they're my past clients, but they just called me about that because I guess that father is sick.
Mhm.
And the only way, I guess he had a stroke and he cannot move. So they're thinking that by moving him out of title, they're gonna avoid all those.
Yeah. See how
Yeah.
anything where they're adding or subtracting is a bad idea, right? Like I don't understand. My clients are the same way as you. I see they switch title like it's nothing, and I'm like, what are you doing? Are you out of your mind? There's reassessment stuff, but they'll just add and subtract people every second. I'm like, what?
This $1 million asset.
Right? Are
you're
you
just messing
kidding
with
me
title.
with this stuff? Right? And they're just not thinking about the horrible ramifications of. I mean, what happens if the house gets reassessed? So yeah, if they take them off, it will get reassessed 50%.
Yeah, so they're looking at the possibilities, right? So this is one of the reasons why I came today because their son is a police officer and he's like, what's the best solution, Maria? What can we do? And they're family in a way. They're my ex-families. So I'm gonna refer them to you guys because I mean, like living trust. And the guy is ill. Like he barely made it out. Like,
Is he getting Medi-Cal right now? Yeah, absolutely. So most people don't realize that you're allowed to own a house and get Medi-Cal.
Yes,
One house. Okay, you're allowed to, right? They have to. The second house is the problem, right? Right. It's the first house you're allowed to own. It's the second house that they're gonna want.
One of them, there are units, both of them, and one of them they leave and they bought it like for $135,000 when it was like now it's like worth so much, but at the same time, then they got a second property, but they're both of them are their units.
So
their income too. So.
Tell it's the cop son or something. So tell him these Medi-Cal people are geniuses.
Figure it out.
They know there's something called a 3-year look-back period, right? You take somebody off title, now you can't qualify for Medi-Cal for 3 years. So if they take him off right now, he will disqualify him for Medi-Cal. right? So when I say they're geniuses, what I mean is they know every stupid little trick that people try. What if I take my title out? What if I add this person on title? What if I... None of it works.
not gonna
Medi-Cal
fool
has
them.
seen every
It
single
doesn't
trick
fool them.
possible. That's why they have it built in that, if somebody wants to hold on to a second house and get free government assistance, it costs a lot of money from us, right? Right? Because it's, the regular trusts are $2,000 bucks, but if you want to try to keep 2 houses and get free government health care, it's expensive, right? Because the government does not want to let you do that, right? They want you to sell the house and pay for your own care, right? Yes, ma'am.
So on the living trust, you can have what, how many properties?
As many as you want.
Yeah.
Oh, you can have as
One
many as
trust, you put all your properties in the trust.
Yeah, it can own 100, right? And it can own, this California trust can own Arizona property or a Texas property or a Florida property. The trick is that as a California attorney, I can't put that Florida property in. You need to have a Florida lawyer put it in from their side, right? I can only touch California properties.
Right. But it can be done on
It could be done. It just has to be done from that state.
Okay, gotcha.
And we have attorneys from other states
Call
reach
us.
out to us to do the California side of their trust.
Like, hey, I'm a Nevada attorney. I got a client who's got a LA house. We can't touch it. Will you put it in there for us, sir? Right, for the right amount of money.
Question, so if I do a living trust and I name my children on there, if one of them is on Social Security now, will they have to pay back their portion of the house when it gets sold to the Social Security?
No, I mean, a couple things. It wouldn't
It's gonna
invest.
avoid.
It wouldn't invest until you died. So it wouldn't, adding them as a beneficiary now wouldn't jeopardize any current benefits because he's just a contingent beneficiary. You could change your mind in 10 years and not have him, right? So it would only affect him once he actually inherited it, not now when you add him.
Okay, so if I were to add now, and that in 20 years, I pass, they're no longer on Social Security, or they are on it, they have to pay back.
Well, no, they're not, because no, Social Security is not it's not like a needs-based program, right? So what is it, SSDI, Social Security
Yeah.
Disability? Okay. So no, they're not gonna have to pay it back, but
It could
jeopardize their future getting those, right? So if you're getting it's usually like $1,000 a month or something SSDI, right? But if you inherit $1 million, they're gonna shut off SSDI for a year because they're like, you don't need this Social Security disability income. You just inherited $1 million, right? So it will potentially jeopardize them to continue to get that money, but it will not. They will not have to pay back the 20 years that they received it.
Okay, another,
One thing on that, you can put a provision in your trust that if a beneficiary is receiving disability, SSDI, that they don't actually inherit that money, so it wouldn't disqualify them for those
That's kind of
benefits.
going more down a special needs trust,
Yes.
right? Or a supplemental needs trust. You're like, hey, this kid is getting government assistance, and so we don't want him to directly inherit the money. We want his brother to inherit it on his behalf,
yep.
right? And so then that wouldn't jeopardize, but then that one kid's never going to get the money, the other kid's going to get it. They're going to dole out supplemental needs stuff.
But how does it like, does the trust do anything in terms to enforce that or no? Like if the kid can receive that money, what is there in the trust to like force that kid to then pay out their sibling?
Yeah, so it goes back to choose wisely,
Yeah.
right?
so I have another question.
Well, let me just finish. So the choose wisely is the ultimate enforcement mechanism on all this because this is just a contract, right? Sure, it's a living trust. It's a different type of contract, but it's just a contract, right? And the people involved are the ones that are enforcing it, right? And so ultimately, if something goes wrong between the people in there, it's court.
Let's go to court.
Right,
The
let's get the
judge will
judge's
figure it out
side.
for
Hey,
us.
my brother won't pay me this. Hey, this. I mean, trust litigation is rampant, right? I mean, it is huge because a lot of people didn't used to have trust. Trust used to be kind of for rich people, but now they're ubiquitous. Everybody has a trust because the cost of not having one's just too damn expensive, right? You gotta have one. So everybody has trust now, right? And so the type of the amount of litigation is horrendous, right? It's my brother won't give it this, my brother, and then you have And it's even where, he wants to do this, I want to do this, we'll have the court decide. So ultimately, that probate judge is the mechanism for any type of infighting, and it's like, it's a petition to remove trustee, right? If the trustee's not following the terms of the trust, you file a petition to remove them and get somebody else appointed, right? But then there's no contest clause that says if one of them sues the other one to get more money, now they're out. So there's all types of moving pieces in this, right? But ultimately, it's just a contract, and so if the people who are enforcing the contract can't get along, they're gonna call mommy, and that the judge is gonna decide, right? But you don't want that, because the judge, it's just brutal.
Can you be very, can you stipulate, let's say for example, one of my kids, and then I decide to put my 2 grandkids on the trust. But I pass, right? And I don't want the parents or my grandkids to touch that. They don't have no say. Can I stipulate exactly saying my grandkids won't touch the property until they turn 18, 20?
Everything is possible, right?
Yeah.
You can't put illegal terms in there.
My ex-daughter-in-law.
Yeah, right. So everything is possible, right? Any type of we call them hooks in there, right? Are possible, right? But it goes back to, you better choose the right trustee to enforce them.
Oh, yeah. No, that's exactly. I know exactly who is the trustee, but I know that the mother of my grandchildren will be like,
we had a client this afternoon.
Those ages in there, 18, 25, 30.
We put all kinds of clauses in there, right? Got to go to college, got to do this, right? Now, the more you put in there, the more likely they're going to head to court, right? The more hooks in there, right?
Yeah.
So I asked the parents, are you doing this because you making yourself feel better, or are you trying to actually help your kids, right? You're dead in this scenario, right? It's called dead hand control, right? It's called reaching from the grave, reaching from the grave and controlling the kids' lives. And so it's a little bit tricky. Our client this afternoon had one kid, and they came in to switch the trust and give everything to the grandkids. Okay, it's called a generation skipping trust. Okay, no problem. It's just one house, and they say, hey, my son's got a gambling problem. I feel like if we leave it to him, he's just gonna lose all the money, and so I'm gonna leave it to his kids eventually, actually. And I said, okay, that's very easy. It's gonna work. But the client wanted to put their son as the trustee.
It's the only person you can't put. Anybody else
I
could
used
have
the
gone
fox
in
and the
there.
hen house
Yes,
example, and they
yes.
still didn't understand it. They kept on saying, no, I want my son. And I said, he's not going to follow your wishes.
That's why the father of my grandkids,
He's going to say, hell no. They're going to
Don't pick
disappear
him,
that
pick
trust.
somebody else.
They're going to, this trust only exists where you guys have it. So as soon as somebody gets it in there, it's gone. There is no second trust. They don't get recorded. Nobody knows what the terms are, right? And so back to choosing wisely, yeah. So I was like, your son's the only person you can't choose. You're skipping him. You're disinheriting your son.
His kids are getting it, and you want to make him give it to them?
He's not going to do it.
No.
He's going to keep it.
Do they still do it?
No, we wouldn't let him.
Okay.
We wouldn't let him. Yeah, they kept on trying.
He kept trying, though. He really did.
If a child is a minor, if your grandkid is a minor, they can still inherit, but they can't sell.
Yeah, so their guardian, right, would inherit it on their behalf and hold it until they became the age of majority and then give it to them.
Oh,
Okay, can you create a
the
state
guardian.
that holds everything and, whatever?
In a state, it would be somebody holding. If they were minor kids when they passed away, it would be held until they were 18.
Yeah. It gets held in an interest-bearing account, right? It's usually the trustee that just holds on, right? So if you choose me as the trustee and I have to give all these kids money until they turn 20, I could be trustee for 10 years, safeguarding that money for these kids' behalf until they turn those magic ages, and now they get it, right? So my trustee job could be 10, 20 years if you have a lot of delayed distributions, right? But if you have a simple one that just says all to my kids, now it's probably going to be closer to 9 months, right? But some people delay distribution for 20, 30, 40 years.
So assuming, let's say that I can't decide which one of my kids, is there,
As trustee or?
as trustees, yeah, is there a neutral person or like an outside,
Yeah, it's a bank.
You can pay banks to be your fiduciary. Yeah.
Yeah, it's called a professional.
What kind of a bank is it? Like a break-
B of A does it, Wells Fargo do it, they'll all do it for you.
Really?
Yeah, for
For a
a
fee.
pretty penny.
How much is that?
It's usually annually, right? So if you put them in there right now, they want you to pay them right now just to have them on there.
Could it be the
And you-
attorney?
Yeah.
Could be the attorney also.
For a fee.
Well,
I mean,
Well, and it's,
I don't
it's,
want to be on the hook for 30 years potentially
exactly.
to be your trustee.
but it's
I don't know what
expensive,
you're going to pass.
right? It's quite expensive. Let's say
So-
you'll probably end up paying somewhere, I'd say 30 to 50, to have that, right? Do that.
If
Yeah.
you want like a neutral bank
A
fiduciary,
professional fiduciary. That's what
you
it's
can
called.
find maybe a family member that's more neutral than the kids are, maybe an aunt.
Yeah.
And then
Yeah.
you don't have to pay them yearly.
Yeah, so we kind of try to ask anybody, hey, do you have brothers and sisters? Have a neighbor that you trust? But if there's nobody, you're going to end up paying the professional bank to do it.
But we
Right,
want
which
to
is
see
not a-
you save your money as much as possible.
Yeah, but I mean, that could be better option than having any of your kids. If you know they're all gonna screw each other over, pick the neutral party.
Yeah.
Right? Or if you know they're gonna never talk to each other again and never get along, just pay the 50 grand. It's worth it, right? I mean, we're brothers. We're not even on our families. It's one of us and then the other one. There's no co, right? Because
We're
we
both
take
beneficiaries.
we take our own advice
We're
too.
co on that, but not trustees.
Talking about the bonus part, do you guys do your own trust, like trust laws? Like, do you guys do your own stuff to write your own wills or on trustees or?
Yeah.
do
Like
it yourself?
all our We
Well,
do all
it's
our
it's
work
like
on it.
it's trust software, right? That gets updated, right, annually. California specific trust software. The hardest part is not the trust itself; it's the grant deed work, right? That's really from our point. That's what you're paying us to do is record the deed with the various county recorder, not get reassessed, and make sure that trust is funded, right? Like I think LegalZoom's not bad at just buying a trust. Right, but it's the other part that's the hard. How do I get this house in there? That's what people, right? And so people will call me and like, I need you to put my house in my trust, and I'm like, who did your trust? Legal? Nah, I'm not doing your legal. They try to end run you.
Yeah.
Right? Like Susie Orman, she tells people, hey, go to LegalZoom and then go to hire the lawyer to do the grant deed. I'm like, no, right? But it's the grant deed work that's the hard part, really. It's not the paperwork's kind of easy. They're kind of standard boilerplate templates. Right? It's the funding of the trust. Right? Let's talk about the other assets real fast. Right? So I said really that it's about the house, but I know you guys got 401ks, IRAs, life insurance, checking and savings accounts. Almost all those accounts we're going to rely on the beneficiaries that you could just list. Right? Wells Fargo asks you when you die, who do you want to get the bank account? The IRA asks you who are the beneficiaries, primary and contingent. Right? And so there's only a couple reasons why you would put the trust as the beneficiary instead of the kids actually, right? And if you're trying to delay distribution for a long time, right? But really, the trust is about the house primarily, and then we try to discourage people to put anything else in there. Some people just want to I want to put everything in there. Like, why? Why? There's no. You only want to put what you need to put in there. There's no reason to put all that in there. All right. Now, if you don't own a house, let's say you just have $10 million, right, in bank accounts, you don't need a trust because those bank accounts have pay on death beneficiaries. It's already a contract with Fidelity, with State Farm, with Bank of America. When I die, I want these people to get paid.
Aren't some banks closing the accounts once you pass, and they won't honor the beneficiaries' rights?
So no. So
I've
it's
heard there are some banks that are doing that. As a matter of fact, my bank, one of them, a credit union, they changed ownership, and then I don't know why I decided to go check on my beneficiaries. I didn't have any. Where previously.
Oh, you
I
had
did
listed
have
benefits,
mine,
so
and
they
I
took
said,
them
what
off.
well, it sounds like in the merger or something, your paperwork got lost. But that's
I said, what happened to my beneficiaries? They said, we have no record. I said, how can you not have record?
so that's a different.
I had to go personally and then put him down again.
Okay.
And we think this is good homework for everybody to talk to the financial institution, see if you have listed beneficiaries, and if maybe the bank messed up, took them off,
Yes.
put them back on there.
Yes,
Yes,
Yeah,
ma'am.
right. And if you got 20 bank accounts, start consolidating. Help the kids out a little bit. Consolidate those to 5 maybe, right? Because the more kind of dead bodies you have, if you got 20 bank accounts, the chances are you're going to forget one of them, and one of them is going to have to be probated, right? One of them is going to not have that pay on death or transfer on death language, right? So yeah. Question? No. Anything else?
Want me to
Yeah.
pass out the-
Yeah, please give everybody a little flyer. Well, thank you guys. Right? Thanks for the questions. Right? Thanks for the questions. Oh, you look for this guy looks familiar.
He does, yeah.
Everybody